Okay, thank you everybody for coming on a warm Friday afternoon to hear the distinguished lecture for the Academy of European Law. As the participants know, Gerard, this is the 30th Academy of European Law, so it's something that's been going on for some time. I'm going to briefly introduce our speaker today, who many of you will know at any rate. Gerard Hogan is Advocate General at the Court of Justice of the European Union, where he was appointed in 2018. And before that, he was a judge in Ireland, appointed to the High Court in 2010 and the Court of Appeal in 2014, where he was often described as the brains of the bench and a champion of rights of individuals. Gerard Hogan earned his PhD at University College Dublin, having studied also at the University of Pennsylvania, where one of his classmates is happily here with him today. And for many years, he was a professor of law at Trinity College, as well as a practicing barrister. So he's one of these rare creatures who really can genuinely combine academia with practice, and there are very few people who can do that successfully. He is a leading authority on the Irish Constitution and a co-author of the leading text on the Irish Constitution, which has been described as a seminal work recognised as the authoritative and definitive commentary on Ireland's fundamental law. Of particular interest to the people in this room, Mr. Justice Hogan, as he then was the referring judge in the reference for a preliminary ruling in the Schrems case, in Schrems versus the Data Protection Commissioner case. In a powerfully argued judgment, Mr. Justice Hogan, as he was, suggested that if this matter were entirely governed by Irish law, then measured by Irish constitutional standards, a significant issue would arise as to whether the United States ensures an adequate level of protection for the privacy and the fundamental rights and freedoms of data subjects. However, as you all know, the matter was not governed exclusively by Irish law, and famously Mr. Justice Hogan stayed proceedings to ask the Court of Justice whether EU law required the Data Protection Commissioner in Ireland to follow the Commission's safe harbour decision, despite the concerns about this decision. In a bold judgment, Mr. Justice Hogan stated that there is perhaps much to be said for the argument that the safe harbour regime has been overtaken by events. The Snowden revelations may be thought to have exposed gaping holes in contemporary US data protection practice, and the subsequent entry into force of the Charter of Fundamental Rights suggested a re-evaluation of the Data Protection Directive and the safe harbour decision may be necessary. As you know, the Schrems case, one of several now, was heard by a grand chamber of the Court of Justice. And the rest, they say, is history, as they say is history, but unfinished history, because Advocate General Hogan tells me that next Tuesday in the Court of Justice of the European Union, there will be a hearing for the next instalment of the Schrems saga in Facebook, Ireland, and Schrems. I had a look to see what Mr. Justice Hogan, Advocate General Hogan, had been up to since his arrival at the European Court of Justice. They seem to have given you rather a lot of VAT so far. It's that conventional for when you start. Perhaps that's something that the newer Advocate Generals are asked to do. But I did notice that you had issued a very compelling opinion in an important case that some of you will be familiar with, which is the Landeskreditbank Baden-Württemberg case, which was the case where the Court of Justice upheld the decision of the General Court, finding that this bank was a significant entity and therefore subject to the exclusive supervision of the European Central Bank. And for those who haven't read the judgment, it's highly recommended, because actually it's a wonderful, succinct tutorial in EU administrative law. So I will certainly use it in my teaching now, having read the judgment. So we're delighted to welcome Advocate General Hogan to the EUI today, where he will deliver this year's distinguished lecture at the Academy of European Law on the topic of rethinking Francovitch and Marleasing. Is there a connection? So welcome to the EUI.
Joyce, thank you very, very much. I think in future a condition of people attending lectures of this kind is that this sort of Very nice introduction, but really should be prohibited. But thank you nonetheless. I'm flattered by your comments. Ladies and gentlemen, I'm going to try and speak for 50 minutes thereabouts on the topic of the formal title of the lecture is Rethinking Francovitch and Marleasing. Is there a connection? And actually, when I wrote it, it is really more about Marleasing than Francovitch, but Francovitch does come in at the end, and you can see that I've tried to tie up the pieces together. But the focus, I suppose, of my lecture is going to be on Marleasing and the subsequent case law. And I dare say some of this is heresy, but I'm trying to express my own views, and my own view is very much against horizontal direct effect for reasons that I will explain. And I also, I suppose, another confession here is that I am really a textualist in the sense that I think judges and courts must focus on the words of a statute as enacted by a legislature, whether in the member states or at the European Union level. And I think that the only way in which you can have true democratic legitimacy is for the courts to remain faithful, so far as they can, to the words of a statute. And again, that's an idea I'll try and come back to. But anyway, when, as we all know, that when the European Economic Community then was founded, there was a variety of new legal problems that hadn't existed before. And one of them was how to deal with this new species of legislation, directives, and what were their status, and in particular, what was the consequence where member states had not transposed the directives into national law, either at all in some instances, or in incomplete or incorrect fashion, as in many other instances, and in particular, what was an acute version of that problem was what was going to happen where there was litigation between private parties, where the directive was in play and where it had not been properly transposed. Now, we know from the 1970s, from the mid-1970s onwards, with cases like Von Dunn and the Home Office, that one aspect of this problem was solved to the point where it's no longer exceptional. The idea of direct effect, that if the directive was clear, precise, and unconditional, that it could be relied on as against the state by private individuals. Or, in one sense, it would be more accurate to say that the state could not plead its own failure to transpose the directive or to do it properly as against the private individual in those circumstances. But the direct effect doctrine didn't solve all problems, and in particular, one problem still remains and is with us to this day. What is the situation where you have an untransposed or an improperly transposed or an erroneously transposed directive in litigation between two private parties? Now, vertical direct effect, that is, against the state or organs of the state, is not a problem because there's a clear legal basis for it in a general principle of law common to all legal systems, namely that you can't profit from your own wrong. And that ultimately is the justification for vertical direct effect. But in the case of horizontal direct effect, that is to say, whether an untransposed or an improperly transposed directive can have legal consequences for a private individual in litigation between two private entities, well, that's more problematic. And the reason it's more problematic is because the defendant, as against whom you are seeking to give effect to the directive, is not in any sense responsible for the failure to transpose the directive. So, the one underpinning of the direct effect doctrine does not apply in the horizontal case. And there's another, or at least two other, general principles which militate against horizontal direct effect, maybe even three. They are, first, the idea that under Article 288 of the TFEU, member states have the choice in form of methods in terms of how to transpose directives. Now, that's nothing to do with the private individual. And even if there was to be a transposition of the directive, the member state has certain choices as to how this is to be done. That's not the responsibility of the private individual, so why should the private individual be made responsible for the state's failure to transpose? And there's also the question of a fundamental constitutional one, I would say, is that apart from regulations, the European Union legislature has never been given the right to enact legislation with direct effect as against private individuals. So if you give horizontal direct effect, in essence you say that what is a directive is converted really into a regulation or something akin to a regulation. Now, and then there is also the due process element, and I'm going to emphasize that when we come to speak about Marleasing, that the private individual is entitled to, as a defendant, is entitled to organise their affairs on the basis that the existing law of the member state, which hasn't been transposed, is that law. And if that's suddenly changed in litigation against another private individual, well, that itself has due process implications. Now, this issue came before the Court of Justice in 1986 in Marshall and Southampton Teaching Hospital. And I'm not going to dwell on the case, but suffice it to say that the court, for all of these reasons, or a variety of these reasons, rejected the idea of horizontal direct effect. And the court, I suppose, in Marshall, stressed the idea that under what is now Article 288 and was then 189 of the Treaty of Rome, that the idea of the member state having a discretion in terms of choice and forms of methods, that wasn't something for the private individual. So that was a key reason why the court rejected horizontal direct effect in Marshall. And then later in Ficini-Dori in 1994, the court added another reason, which is the one I've just mentioned, and the court said, if the possibility of relying on a provision of a directive that has not been transposed or has been incorrectly transposed were to be extended to the sphere of relations between individuals, that would amount to recognising a power in the European Union to enact obligations for individuals with immediate effect, where it has competence to do so only where it is empowered to adopt regulations. So essentially, Ficini-Dori is saying that you can't have horizontal direct effect because that would be the consequence of it. Now, so much was clear in terms of the case law from Marshall to Ficini-Dori. But in the meantime, there had been two important decisions. One in November 1991, Francovitch, which I'm only going to mention very lightly here because it's just recognizing the general possibility of liability against member states for failure to transpose directives and for breach of EU law generally. But in November 1990, there was the leading decision in Marleasing. And this is regarded, of course, as a landmark decision in terms of the interpretation of directives generally, and in particular in terms of the principle of interpretation conforme, the idea that national courts must be prepared to adopt an interpretation of national law which, quote, so far as possible in the light of the wording and purpose of the directive in order to achieve the result pursued by the latter and thereby comply with the third paragraph of what is now Article 102.88 TFEU. Now, you might think that that's an unexceptionable principle, that the courts of member states were obliged so far as possible to interpret their national law in line with European Union law. And insofar as it goes, it's true. but I think there are some underlying difficulties and that possibly haven't been focused on. And while you can say that the member states' duty of loyal cooperation and good faith requires this sort of result, let's take a look at some of the details. The actual details of Marleasing are sometimes overlooked. Now, what was it about? It was a dispute between two Spanish companies in which Marleasing, the plaintiff, contended that the principal defendant company, a company called La Comercial, was in fact a sham company established by another entity called Barvisa SA, and Barvisa had transferred its assets to La Comercial. So what happened was that B is a creditor of Marleasing, and the allegation is that to avoid this debt to Marleasing, it transfers its assets to a new entity called C, La Comercial. And at that point, however, the lawyers for C came up with what you might think was an ingenious new argument. Because what Marleasing were doing in the Spanish courts were saying that the establishment of Comercial was a fraud, was a sham. It was designed to it was a fraud on its creditors, because Barvisa was transferring its assets to Comercial and thereby trying to, as I say, undermine Marleasing's status as a creditor. And under the Spanish Civil Code, you had the capacity to, or there was you could take proceedings to have a company, the establishment of a company declared void for what was called lack of cause. In other words, what Marleasing were doing in the Spanish courts was saying, wait a minute, the establishment of Comercial is a fraud on us, and therefore that company should be annulled. Effectively, it should be the establishment of the company for this purposes should be annulled. Now, they had possibly other remedies under Spanish bankruptcy law or law relating to debtor and creditor. They could have, perhaps in other countries, you could have said that the transfer of assets from Barvisa to Comercial was a fraud on the creditors and should be set aside. But under Spanish law, there existed the possibility of having the actual establishment of the company declared void. And that's what Marleasing wanted to do. Now, there was only one problem. That under the first company law directive from 1968, the Article 11 had listed exhaustively the cases in which the nullity of the establishment of a company might be judicially ordered. And lack of cause was not one of them. So in other words, Article 11 had set out the circumstances in which the establishment of a company could be annulled. But just because you said it was a sham company, that wasn't one of those grounds. And as I say, La Comercial responded by saying, wait a minute, the proceedings to nullify us as a company is contrary to Article 11 of the first company law directive, because it doesn't allow this in this situation. Now, there's only one problem with that argument, which was that Spain had never actually transposed the directive. So, just let's recap again. We have a situation whereby Marleasing is owed money, it says, by Barvisa. Barvisa comes up with this plan, so Marleasing says, to establish a company called La Comercial. Barvisa transfers its assets to La Comercial, and Marleasing says, wait a minute, that's a fraud on us, and the establishment of Comercial should be annulled. It's not a valid company. La Comercial says, that's okay, because under Article 11 of the first company law directive, there are grounds for nullifying the establishment of a company, but an allegation of fraud or as the Spanish Civil Code put it, establishment for lack of cause is not one of them. And then Marleasing said, well, in turn, that's okay, because that first company law directive has never been transposed by Spain. So the stage was set then, following a reference from the Spanish courts to the Court of Justice, as to how would you deal with this particular problem. Now, the response of the court was interesting. It referred to Marshall and Southampton Teaching Hospital, said there's no horizontal direct effect, and then it also refers to von Coulson, the line of authority which says that the general obligation of member states to take all appropriate steps to ensure the fulfilment of the obligation to achieve the result envisaged by the directive, and this was binding on all member states, including their courts. And then it went on to say, I'm quoting, in applying national law, whether the provisions in question were adopted before or after the directive, the national court called upon to interpret it is required to do so as far as possible in the light of the wording and purpose of the directive in order to achieve the result pursued by the latter and thereby comply with the requirements of what is now Article 288 of the treaty. And then the court said, the Spanish court must interpret its own law in conformity with Article 11 so that any interpretation of that law which was at variance at the term of the directive was thereby precluded. But you might ask, what's really happening here? What's really happening, I would say, is this, is that Marleasing's cause of action against Barvisa and La Comercial is effectively nullified because the court is telling the Spanish courts to interpret their law in conformity with the requirements of the directive. But that interpretation conform has the result which is very close to a situation of horizontal direct effect, because it means that Marleasing's existing cause of action no longer obtains, because it's not possible to interpret Spanish law in conformity with the requirements of the directive. So I would say that Marleasing is something very close to a form of horizontal direct effect. Now, if you believe that in any ordered legal system there should be a direct link between legal default and legal liability, then there has to be a little bit of difficulty with this form of reasoning. Because, if you're a lawyer, if you were Marleasing, you could say, why should it pay the price for inaction, which was the exclusive responsibility of the Spanish state? Now, let's ask how Marleasing has fared since it was first delivered. And at one level, Marleasing has been extended, and at another level, it has been limited. The key words, I suggest, in Marleasing are as far as possible. So a member state court is required as far as possible to achieve a result which is in conformity with the requirements of the directive. But that has meant in a lot of cases that ordinary standard principles of interpretation of statutes have been, to some extent, almost moulded out of shape in order to ensure that the directive is interpreted in a way, or that the directive isn't, the national law is interpreted in a way which conforms to the directive. Now, I'm going to just take a look at a number of cases which postdate Marleasing. First is a case called Pfeiffer from 2004, where concerned the Working Time Directive. And under the Working Time Directive, there was an exclusion for those engaged in transport. And the German legislature assumed that emergency care workers working for the ambulance service were transport employees in this sense, and therefore they were excluded. It felt it excluded them from the terms of the directive. Um, in Pfeiffer, the question was, in litigation against the Red Cross, which is a private company, did the Working Time Directive enable these emergency care workers to get appropriate time off? Essentially, were emergency care workers working in the ambulance service covered by the Working Time Directive? The German legislature, the Bundestag, had enacted legislation to give effect to the Working Time Directive, but assumed that emergency care workers were outside it. The court first held they were inside the directive, and that particular exclusion didn't apply. So we're then in a situation whereby you have got, objectively, I suppose, a breach of EU law. But what's to happen now in the litigation between Pfeiffer, the emergency care worker, and the German Red Cross, so far as the Working Time Directive is concerned? The court said it referred to the principle of interpretation conforme, but it said that it requires the national court to consider national law as a whole, to assess to what extent it may be applied so as not to produce a result contrary to that sought by the directive. In that context, if the application of interpretive methods recognised by national law enables in certain circumstances a provision of domestic law to be construed in such a way as to avoid conflict with another rule of domestic law, or the scope of that provision to be restricted by applying it only insofar as it is compatible with the rule concerned, the national court is obliged to use these methods. So it went on to say that the national court was obliged to the greatest extent possible to interpret its national law in conformity with the directive. And again, it's sort of difficult to avoid the conclusion that there is something close to horizontal direct effect going on here, because this, after all, is litigation involving private individuals. For good or for ill, the German Red Cross assumed, in conformity with the national law enacted by the German Parliament, that the Working Time Directive didn't apply to it, and yet the Court of Justice is effectively saying it does, and that the national courts are, to all intents and purposes, required to mould their national law to comply with the directive. And you have also a number of subsequent cases that illustrate this principle. There's a decision called Björn Schule Fruchtindustrie, where the Spanish from 2004, where the Swedish court had to consider an issue in terms of all things, whether a particular trademark for gherkins should be revoked on the ground that the name was generic. But above all of that, details about trademarks and so on, the Court of Justice, the Swedish court said, if we apply our own rules of interpretation, we should be arriving at result X. But even though that result X is contrary to European Union law. The Court of Justice said, however, that really the Marleasing required the Swedish courts to apply the interpretation which was compatible with the directive, notwithstanding any contrary interpretation which may arise from the travaux preparatoires for the national rule. So in other words, if the Swedish courts allowed the use of preparatory documents, and that was the basis on which they construed their own national law, they really shouldn't do that if the result was contrary to European Union law. Now, there are some limits. And in particular, the big limit is that of contra legem, the idea that you cannot interpret the law in a way which is contrary to the actual text of the law. So if the law says black and European Union law says white, or the directive says white, you can't, in a sense, reinterpret the black to become white, because that would be contra legem. It would be contrary to the actual words of the national law. And the court recognized the questions of due process and fairness and so on, that you were interpreting what was essentially black to mean white. In that situation, the national court probably couldn't interpret or shouldn't interpret its own national law in a manner compatible with the directive, because that simply was not possible. But while this idea of contra legem is frequently cited, there have been a series of cases which show the limits of the contra legem doctrine. Now, I'm just going to mention two in particular. One is three from the last 2 to 3 years. One is a case called DI, Dansk Industri, where was a reference from the Danish Supreme Court, and it concerned one aspect of Danish pensions law and whether it was compatible with the Equal Treatment Directive. The Danish court said that they couldn't give their own domestic legislation an interpretation which was compatible with requirements of EU law. But the Court of Justice was very, very reluctant to accept that, and it really gave a sort of Marleasing plus style interpretation. For example, it said that it should be noted in that connection that the requirement to interpret national law in conformity with EU law entails the obligation for national courts to change its established case law, where necessary, if it's based on an interpretation of national law that is incompatible with the objectives of the directive. So the national court cannot validly claim that it is impossible for it to interpret the national provision at issue in a manner that is consistent with EU law by mere reason of the fact that it's consistently interpreted that provision in a manner that is incompatible with EU law. So in other words, what the Court of Justice was saying in DI was that if you've been interpreting your national law in a way that is objectively incompatible with the directive, well, you had better change that national law. And you can't come and protest to us that this is contra legem, that we can't do it. Of course you can. Go back and do better and reinterpret your own national law in a way that makes it compatible with the directive. So this was a sort of, this was very much a full-blooded application of Marleasing. And you could say, and some might say, that this is really a form of horizontal direct effect, because again, in litigation involving private individuals, a directive which has not been transposed or not properly transposed is been given full effect, even as against that private individual. Now, I'm going to mention two other cases, and one called Smith from 2018, and another case called, well, there was a series of them, but Bauer and Egenberger and Max Planck. There's a series of cases. I'll deal with them collectively. Again, Bauer a decision, Max Planck a decision from last November. But let me just start with the case of Smith and Duggan, or Smith, as it now is, from a judgment of the Grand Chamber from last August. Because, well, as it happens, is a case I had some involvement with as a judge in Ireland, but it illustrates this point very, very well, and it shows sort of the limits of the Marleasing doctrine. And I'm going to compare Smith on the one hand with the Bauer line of case law from last November on the other, and then say something about Francovich, and try to do that in the next 20 minutes or so. In Smith, Mr. Smith had been involved in a terrible accident in 1999. He'd been traveling in the rear seat of a van which had no fixed seat. So it was like one of these vans where you might have, say, 2 seats in the front, and then there's a compartment in the back generally for the transport of goods and that sort of thing. And Mr. Smith was traveling in the back of the van where there was no fixed seat. There was a terrible accident. He tragically suffered catastrophic injuries, and so catastrophic were his injuries that the Irish High Court awarded him €3 million as against the other parties. So it was an absolutely tragic case. Now, Ireland, like every other EU country, has had mandatory motor insurance since the 1930s and possibly earlier. But at the time of the accident, there was no mandatory insurance where you were traveling in a car or in a van with no fixed seats. So there was an exclusion for cover where you were traveling in the van and you were sitting in the back of it and there was no fixed seat. Now, why that was so, I can't give an answer, and it certainly had tragic consequences for Mr. Smith, but in any event, that was Irish law as it stood. Now, the interesting thing about Smith was that obviously the van had insurance cover, but in compliance with Irish law at the time, it did not extend to injuries caused to people who were sitting in the back of the van without a fixed seat. So, for example, the driver of the van who was sitting in a fixed seat would obviously be covered by the insurance. But there was an express exclusion of persons sitting in the rear of the van. Now, that was the basis on which the insurance company wrote the policy. And that was the policy of insurance, and that was the basis on which the premium was paid. And I dare say that in 1999, if you had said to the insurance company, I want cover for people who are traveling in the back of the van, even though that's not required under Irish law, they would have quoted you a price for it, probably, I don't know, but you can certainly assume it would have been a higher premium because clearly there would have been an additional risk factor. Obviously, the risk to people being injured is far greater if they are sitting in a van without a fixed seat as is compared to when they're sitting in a van with a fixed seat. Now, question then was, after the award of damages to Mr. Smith, who was to pay it? And in particular, what was this to be paid by the insurance company? Now, while all of this was going on, there had been a lot of litigation involving Ireland before the Court of Justice concerning the interpretation of the motor insurance directives. And in a case called Farrell in 2007, the Court of Justice held that the Irish law was incompatible with the third insurance directive. In other words, Ireland couldn't properly have no insurance cover, mandatory insurance cover for people traveling in the back of a van without fixed seats. So that exclusion in Irish law of persons travelling without fixed seats was held to be contrary to the third insurance directive in 2007. Now, when Mr. Smith's case came before the Irish High Court in 2009, now why it took 10 years to come before the Irish High Court, well, I don't know is the answer, but we won't dwell on it. But anyway, when it came before the Irish Court in 2009, you had a situation whereby the Court of Justice had already ruled that the Irish law was incompatible with the directive. What was to happen? Who was to pay the $3 million? And in particular, was the insurance company to pay the $3 million, or would somebody be left to a Francovitch remedy as against the state, against the Irish state, for failure to transpose the directive? The High Court held, applying Marleasing, that the High Court judge said he was going to interpret the relevant legislation to overlook or ignore the exclusion permitted therein in respect of liability for injuries caused to persons such as the plaintiff in this case. So in other words, what he said was, applying Marleasing, I have to give this an interpretation compatible with the directive, and therefore I'm going to ignore or overlook the specific exclusion in the legislation for persons travelling in the back of a van without fixed seats. And on that basis, he said, I'm ignoring that. In essence, I'm going to almost strike, he didn't use those words, but he's almost going to strike out that provision, and therefore reading the legislation that way, it meant that the insurance company picked up the liability for the 3 million award. But again, remember, the insurance company is a private individual, a private entity, and it had never, if you like, contracted for this risk. Came before the Court of Appeal, and I was a member of the panel, and we concluded that an interpretation conforme was not permitted. In other words, that we thought that the language of the law was so clear, it, if you like, in black and white terms said, there's an exclusion here for persons travelling without fixed seats, and we can't ignore those words. And we therefore referred the question, we said these exclusions clearly represent what must have been understood at the time to have been a legislative policy choice, in that they were plainly quite deliberate and are obviously not the product of some legislative oversight. Private parties, such as the insurance company, quite obviously acted on foot of these excluding provisions. There can be little doubt but that the cost of the insurance policy written by the insurance company reflected what it legitimately understood to be the limits of its insurance risks, and these risks did not extend to passengers travelling in vans which didn't have fixed seats. So that's what we thought in the Court of Appeal, and we referred the issue to the Court of Justice. Now, we had assumed, and the Court of Justice told us wrongly, that the fact that the Irish law had already been held to be invalid meant that we could no longer apply it, that it was gone. That it was a bit like, for those of you who have got judicial review of legislation in your own member states, it's a bit like a declaration of unconstitutionality. It applied erga omnes, that in other words, once the law was held to be invalid by the Court of Justice, it was gone. And we presumed in our reference that that was the situation. But when the case came to the Court of Justice, they told us in that respect we were wrong. And what the court said, in very interesting judgment, said is that applying in a sense Marshall and Southampton Teaching Hospital in reverse, you can't have a situation of horizontal direct effect. So therefore, just because the Irish law we've already held the Irish law to be contrary to the provisions of the Third Insurance Directive, doesn't mean to say that it's gone for all time. And therefore, you can continue to apply the old Irish law even in cases involving or especially in cases involving private individuals. It's only where it's against the state or state entities that that law is gone. Now, the net effect of that judgment was this, is that when the case came back to us in the Court of Appeal, and the case at that point was then settled, but what it meant was this, was that an Irish court could continue to apply the old law even though it was contrary to the requirements of European Union law in litigation between two private individuals, because to do otherwise, the court said, would be a form of horizontal direct effect. So Smith is an example of, if you like, limiting the effect of it's much more in line with Marshall than Marleasing. The National Court is saying we can't interpret our national law incompatible with the directive. The Court of Justice has said your national law is contrary to the requirements of EU law, it's contrary to the directive. But in Smith, they say that if you are involved in litigation between two private individuals, well, you don't have to give effect to the requirements of EU law, because that would be a form of horizontal direct effect. So Smith is quite an important limitation, therefore, on the Marleasing doctrine. But just as that is happening, and you have the requirements of the contra legem doctrine, there's something else is happening on the other side. And that's in a series of cases of starting with a case called Eggenberger in April 2018, but also two other cases from last November called Bauer and Max Planck Institute, where again what the court is doing is this issue of horizontal direct effect in the field of employment law. So, for example, in Max Planck, you have got issues in terms of leave entitlements. In the other cases, it's equality. So these are provisions in terms of fundamental issues of employment law. And to what extent does the Marleasing doctrine apply there? Now, the court distinguished Smith because it said Smith was a case about the motor insurance directives, important undoubtedly, but not relating to fundamental European Union values. And here's the new development, which is that the cases Bauer and Eggenberger and Max Planck all concerned directives which were designed to give effect to fundamental provisions of the Charter in terms of employment law. And that was the new distinguishing factor. So where the directive is giving effect to a requirement of the Charter, then it seems that Marleasing applies with full force. And it seems, on one reading of these judgments, which I think require very close consideration, but on one reading of these judgments, the court is coming close to saying that they can have horizontal direct effect. Certainly in litigation involving private individuals, where you've got private defendants, where the defendants are private entities, such as the Max Planck case, all these three German cases, private entities, the Court of Justice is saying that the national courts are obliged to give effect to the requirements of the directive, because the directive is giving effect to a charter entitlement, or in some instances, obligation. Now, this raises a further question which would require a lecture in itself, which is to what extent does the Charter produce rights as against third parties, against private individuals? After all, the Charter is principally directed, you would have thought, to the member states. But can it produce consequences for private individuals? If you look at the concluding provisions of the Charter, Article 51, 1 of the Charter, which is in some ways the most important provision of the Charter, most single important provision of the Charter, it says that the Charter and its rights are addressed to member states only when they are implementing union law. So on one interpretation of the Charter, based on Article 51.1, you'd have said, the Charter is great, but it only applies to member states and only when they're implementing union law. And it doesn't apply, you'd have thought, in litigation between private parties. But these three recent cases seem to cast doubt on that, and they seem to suggest that where the directive is giving effect to a Charter right, then despite Article 51.1, the court has said that while the Charter is primarily, note the word primarily has crept into the discussion, while the Charter is primarily directed to member states, that does not exclude it producing rights as against private individuals. And that was a further factor which persuaded the court, in essence, to give something very close to horizontal direct effect to these directives in these cases. So just before we consider the Francovitch matter now, before I conclude in the next 5 minutes, can sum up by saying that the present state of the law is that on the one hand you have the contra legem doctrine and the Smith case, which places a limit on Marleasing, which says, Marshall and Southampton Teaching Hospital, right through to Smith, that in most directives, if it's contra legem, you can't give effect to, you can't have horizontal direct effects. And that even includes, as in Smith, a case where the law in question has already been declared to be in contrary to European Union law. The member state court is not obliged by EU law to give effect to that declaration of invalidity. It can continue the old law so as to avoid horizontal direct effect. So that's one stark line of cases from Marshall in 1986 up to Smith in 2018. And on the other hand, and you could include Ficini, Dori, and Peppino and all the cases dealing with contra legem in the middle of that as well. And then on the other hand, you have a series of cases from Marleasing, and then with the new twist or development in the most recent line of cases, Bauer and Eggenberger and so on, that where the directive is giving effect to a fundamental right. And remember, this was the basis in which Smith was distinguished, because Smith wasn't giving effect to a fundamental right. It was concerned with the motor insurance directives. But where you're concerned with the fundamental right in relation to employment law, which is protected by the Charter, this is, if you like, a super-added reason to have a full-blooded application of Marleasing. So, I come back to the title of my lecture. Rethinking Francovich and Marleasing. Is there a connection? So far you might say, well, you've heard a lot about Marleasing, but what about Francovich? And is there a connection? Well, in the remaining 2 or 3 minutes, I'll tell you what I think the connection is. In the common law world, in one legal family at least, there is a doctrine of textualism, which argues that judges should not readily, and I underline the word readily, depart from the ordinary meaning of the legislative text, because to do so would effectively involve rewriting it, thereby undermining the legislative and ultimately the democratic process. I mean, the argument is that if the law says you must do A and B, a court cannot legitimately interpret A and B to mean A, B, C, and D, because that's effectively legislating and usurping the democratic role of the legislators in that legislative body. And there's a further objection to that type of departing from the text, or readily departing from the text, is that the private citizen can really only regulate their affairs, if needs be with legal advice, by reference to the actual legislative text. So if the legislative text says A and B, the private citizen can either read the text and say it means A and B, I don't have to do C and D, or they can get legal advice and says you only have to do A and B and not C and D. So that's the, if you like, the democratic due process basis for focusing on the words of the legislation. Now, I'm the first to recognize that there are limits to this. Language, I've given obviously a very easy example in my A and B example. Quite often, legislative text, as we know, is inherently ambiguous. Even the best drafted laws lead to absurdities or bring about a result which the legislator never intended. And in that situation, you sometimes have to depart from the actual words of the text. But I think one of the difficulties with Marleasing is that in its objective of ensuring EU law is complied with, a very commendable objective, it may have to some extent require the remoulding of the ordinary meaning or the ordinary rules of statutory interpretation or legislative interpretation in each member state. And if that happens, you're going to have a form of horizontal direct effect. So, I come back to conclude. Is there a connection between Marleasing and Francovitch? And Francovitch being the idea of liability on the part of the member state for breach of European Union law. I believe that there is. I think that part of the problem here is that the rules for state liability in Francovitch are probably too restrictive. Now that's a topic for another lecture. But if we just accept that for a moment, I would say that it's wrong that citizens should lose out by reason of the failure of member states to live up to their fundamental treaty obligation to transpose directives in appropriate manner, or even in some cases at all. So I think we can accept that the obligation is on the member states. But my basic point is that where you have litigation, like the Marleasing type of case, where you have an untransposed directive, or an improperly transposed directive, and you have a plaintiff and defendant who are two private parties, I think that's wrong, that one of them should be compensated as against the other in order to comply with European Union law. I mean, if we go back to the unfortunate plaintiff in Smith, the man who suffered life-changing catastrophic injuries by reason of the motor accident, we would, I think, every one of us agree that, that ultimately he should receive compensation for the failure, if needs be, receive compensation for the failure of Ireland to have met its obligations under the Motor Insurance Directive. But the question is, who's to do it? Who's to do it? Should it be, at one level, and one's human level, we could say, well, Smith should be compensated, so therefore we're going to give a Marleasing interpretation of Irish law and require the insurance company to pay, even though the insurance company say, wait a minute, we were just complying with Irish law at the time. We never wrote a premium to reflect this risk. So the Marleasing doctrine essentially can lead to a situation whereby, in order to comply with European Union law, one group of litigants, one group of private litigants, is benefited at the expense of another group of private litigants. But the private litigants who are disadvantaged as a result of this, like what happened in the Irish High Court to the insurance company, where it suffered this Marleasing interpretation, it has to pay out for the failure of Ireland to comply with its obligations. And I would say that's wrong as a matter of principle, that a private individual should not have to suffer for something that was not its responsibility. That insurance company, whatever its faults, was not responsible for the fact that the third motor insurance directive had never properly been transposed by Ireland. So that's one argument. And the second argument is those types of risks in modern states are borne by the state themselves and not by private individuals. So I would suggest that the future direction is this, or ought to be, or at least we ought to be thinking about, relaxing the Francovitch rules and perhaps restricting Marleasing. In other words, that we all agree on what the problem is. Failures by member states to transpose directives. There's two broad solutions. One is to give, dare I say it, an artificial interpretation to national law, a la Marleasing, to make sure that national law complies with EU law. You've heard for the last hour what I think some of the difficulties with that can be. But there's another solution, which I have too lightly touched on this morning, which is Francovich, and acknowledge that there's a breach of EU law on the part of the member state. But the remedy is damages for the party who is the victim of that failure to transpose the law. That's already admitted in principle since Francovich, And the case law hasn't really moved on, perhaps to some degree, since Brasserie to Pécher and various other cases in the mid-90s. I think there's room for further development here, and that in this constant ebb and flow between statutory interpretation on the one hand and damages on the other, as a means of ensuring that EU law is complied with in this sphere of unfulfilled directives, that the emphasis perhaps should be more on the damages and less on the statutory interpretation. So in a word, ladies and gentlemen, there is a connection, and I think it should be more Francovich and less Marleasing. Thank you so much.